welcome to Legally Speaking with me, Tarun Nangia. Today, we're going to discuss the review petition against the PMLA judgment, famously known as Justice Khanwilkar's judgment, which was, in a sense, which was authored last year. And of course, now the review petition is being listed before the Supreme Court. What we're going to discuss today that the aspects of the PMLA law that are going to come up before the bench of the Supreme Court on this case. Also, a lot of promoters are wanting to know about what happens to issues like the Enforcement Case Information Report, which is the ECIR, Section 45, which is twin conditions for bail in money laundering cases. Also, there are definitely other issues involving attachment position. We will go into each one of them. I have somebody who deals with these cases on a day-to-day basis. I want to welcome Advocate Malak Bhatt. He's co-founder of NM Law Chambers, and he will share with us also the details of the review petition, what all issues will be challenged, why there needs to be a resolution to these issues. Good to see you, Malak, and looking forward to some interesting anecdotes, interventions, and analysis from you.
Thanks, Tarun, for inviting me.
And at the outset, may I request you to first, in about the first 2 minutes, authored in the year 2022. Over to you.
Sure. So as you know, the PMLA was enacted in 2002, came into force in 2005. There were various amendments that took place between 2015 and 19, and hitting impact not only on the business sentiment of the country, but also at a constitutional level, affecting a lot of rights of people who are accused in money laundering cases. So there were a batch of petitions which challenged the vagaries of the amendments and the manner in which the act was trying to be worked around by the ED, by the agency. Last part of this challenge were about 7 or 8 big grounds, and on all the grounds, the Supreme Court held in favor of of upholding the PMLA, largely looking at the sentiment that because India was part of the UN Convention Against Terrorism, was a part of and a signatory to the FATF, the Federation of Anti-Terrorist and Money Laundering Foundation, that if the country does not resound the sentiment of the international arena of anti-money laundering, then we will fall out of our international obligations. That was the larger sentiment in which the judgment came about. 7 or 8 issues with the judgment goes into, and we'll try and see as many as we can cover. But when the review came up, one of the 2 things that I can in fact point out in what happened in court, when Justice Ramanna took up the review in open court, before the argument could start, his very first thing was that the judgment says that the ECIR, as you said, the fulcrum of how the investigation by the of the ED and need not be shared with, need not be made public or need not be shared with the accused. His first reaction before the arguments on behalf of all the petitioners and all the accused who were in part of the petitioners herein, found a lot of encouragement that, look, there is someone who understands that there are various issues which still need to be reconsidered at a holistic level because it involves a lot of constitutional issues now. So if you permit, I can start with that issue now. So ECIR, let's just break down the concept. As you know, any formal agency, any investigating agency, when it starts an investigation, the investigation has to be launched basis some information which it finds has been committed. Let's take CBI. So when CBI starts an investigation, it registers a regular case, an RC, through an FIR. Now, Supreme Court in a judgment way back in Vineet Narayan said that because the FIR is a document which contains the allegations against the person, it is the formal document which allows the investigating agency to initiate the investigation. That document has to be made public. That document has to at least be made available to the accused. In fact, that procedural safeguard is provided even under our CRPC. Section 207 of the CRPC says that a copy of the documents filed before the court, and in fact, even the FIR is registered and filed by the prosecuting agency before the court, is to be given. So if that is the procedural safeguard available to an accused under CRPC, then similarly, the ED, which is also an investigating agency, has to make this document available. CBI, in fact, interestingly, CBI has been mandated by the Supreme Court to upload all its FIRs on the CBI portal, on their website. The Supreme Court, in the case of ED, in Vijay Madan Lal Chaudhary's judgment, says that, look, it is only an internal document which allows the ED to record their satisfaction, their internal satisfaction on what they feel is the prima facie offense of money laundering in a case. Where the Supreme Court, in my respectful submission over here, faltered was that when a predicate offense is committed, the ED comes in when it feels that the predicate offense has given rise to a proceed of crime, and that proceed of crime has been used in a particular manner to actually come to a conclusion that a money laundering activity could have taken place. Let's take an example, a very simple example. There is an offense of cheating, and there is some amount which is taken out from a company. Say I've told the company that I want a loan from you and I'll repay it in so and so time. I've cheated the company, I've taken that money, I have siphoned it out somewhere. Prima facie, in a lot of these cases, this may not be a money laundering exercise, and some it may be. But that satisfaction is where the ED's ECIR will reveal what they feel is the proceed of crime and what they feel is the money laundering exercise.
The basic, if I break it down into businessman's language, all he wants is that if I should know what is the complaint against me.
Absolutely, that is all. Because
and how do I defend myself? I mean, is that that is what he is wanting?
Precisely. From a very layman's perspective, if you ask me, what is the amount that I have been alleged to be involved in? And where is the ED saying this today amount I have either siphoned, diverted, tried to convert into untainted money? That allegation, that fulcrum is where the ED will actually tell you.
Very quickly, my follow-up question is, in case the businessman does not have a copy of the ECIR, what is the dilemma of his lawyer? How does he argue in court? And what is the risk?
The risk is very high at two levels. Number one is if I have to actually make an allegation that this ECIR is completely baseless, or if your contention is that there actually has been no criminal activity, I cannot prove that till I have the document in my hand. Number one. Number two, it's worse off because in an ED investigation, if someone is to be arrested, and which will then take us to our next topic, if someone's to be arrested without actually seeing the prima facie basis on which the allegation is made out against me, there cannot be a probable defense that I can raise.
Okay, point well taken. Now we go to the next issue, which is, I think, the heart of the review petition, which is section 45, which is twin conditions for, in a sense, bail, where the judge has to record a finding that that you are probably innocent in order to give you bail. So before the trial itself, the judge has to record such a finding, which is absurd. But could you help us understand this issue from inception? As in there was a judgment in 2017. What happened then? How was this resurrected? If you could just make us understand this whole issue.
We largely know about this. The loose term used is twin condition because these conditions are slightly more stricter than the normal bail conditions contained in our CRPC, which is section 437, 439. The two conditions in all these cases is that one, the prosecutor has to be necessarily given notice of the fact and allowed to oppose the bail petition. The second, which is the more important part, is that the court has to be convinced at the time of granting bail that prima facie I have not committed the offense. Now, what does this do? From a it creates two conundrums. Number one, if prima facie I have to show that I have not committed the offense, it reverses the burden of proof. As we all know, the general criminal philosophy is that one is innocent until proven guilty. Whether I have committed the offense or not is actually the prosecution's burden to discharge beyond reasonable doubt that I have not committed the offense. If at the bail stage, if I'm supposed to show the court that I have not committed the offense, effectively I am being put in the shoes of the prosecutor to say, okay, fine, I'll do their work now. They have arrested me, they have done what they have to. And the allegations against me, I have to go and break them down and prove that they're wrong. It kind of tries to create a mini trial at the bail stage. Now, very logically speaking, if someone is facing trial, say the evidence is loose, there are some loopholes, there are a lot of black holes in the way in which the prosecution case is made up. Punctured, that I will create that reasonable doubt. Now, if I have to show that I have not committed the offense, practically from the arrested promoter or director or person's side, I will have to open up my defenses, because I'll have, if it's a transaction-based case, say the case is that you have diverted funds, I will have to open up my books, I'll have to open up my balance sheets, I'll have to open up my transaction to show how the transaction actually took place. So my defense comes out. Now, what happened was that this fallacy in section 45 was addressed in Nikesh Tarachan by Justice Nariman, and beautifully so. He said two things, and that time there was also an error in the way the section 45 was drafted, because it says that this twin condition will apply to prove that you will have to prove that you have not committed the predicate offense. Effectively, he says that can't be, because you are arrested. You need not prove that you have not committed the predicate offense, because you may not even be involved in the predicate offense. Say someone has cheated, someone has robbed a bank. A robs a bank, gives the money to B, and B is actually the person who launders the money. B still may not be part of the actual robbing, so he may not be in the predicate offense. That conundrum, he says, this shows that there's a violation of Article 40, which in 2019, by way of an amendment, whether the amendment was right or wrong is a separate question, but the legislature tried to address that and change the language. The second very important part that he hit on was that this is violative of a basic fundamental right to life. And that right to life under Article 21 includes a right to fair trial. That fair trial would mean that I have to show my defense at the stage of trial, not at the stage of bail. This is something which the Supreme Court in this judgment in Vijay Madan Lal did not address at all. It simply said that, look, it meets the requirements of a UN convention, it meets the requirements of India's international obligations, and therefore we find this provision to be reasonable. Now, where is the problem here? These twin conditions, if you see, and we've done a comparative study also on this while we were arguing this, led by Mr. Rodgi, in fact, at one point. Used in statutes where the national interest is being heard. So there's TADA, there's POTA, there's NDPS Act. Statutes which actually are dealing with heinous offenses. The legislature, interestingly, in the PMLA has made the maximum punishment years. So in terms of the legislature's own mind also, this is not an offense as heinous as terrorism or drug peddling. So if that is the case, then the twin condition does not reasonably have any nexus to the way the legislature is drafted. And that is an issue which today is hurting the courts also the most, because large part of the court's time in ED trials, and that is being spent in bails. Interestingly, in 2 days back, Justice Kaul had made a statement that 33% of the matters which come up to Supreme Court are bail hearings, and therefore it's time to introspect. And that introspection actually will lead to this.
In very important comment by Justice Kaul, indeed, I'll want to ask you, in the review petition against this PMLA judgment, are they requesting to make twin conditions unconstitutional again, like what had happened in the Nikesh Tarachan Shah judgment in 2017?
Yes. So there are, I'll just elaborate on this also. There are two grounds on saying that Section 45 does not stand. Ground one is that since in 2017, and this is court had already struck down the provision, till the time it is re-enacted, put before the legislature and passed by the legislature through a parliamentary statutory enactment process, it cannot stand resurrected. So merely by changing that one word in the first line of Section 45, the section does not stand resurrected. So in fact, the first argument is that Section 45 today also is not on the statute book. So you could not have ruled upon its validity at all. The more important argument is to say that you have not dealt with the principle laid down in Nikesh Tarachan. You have not appreciated the fact that courts time and again have dealt with this issue that twin conditions are valid only in egregious and heinous crimes. And that is the main, in fact, because even if let's say all arguments are to be accepted and the reviews to be dismissed, if this one point goes, if Section 45 goes, it will actually benefit a lot of trial processes in getting completed, because a lot of times courts are also spending most of the times in bail. that we see there are about 14, 15 accused people. Every person stands arrested, gets into a bail process. The trial does not proceed. So even from a court timing perspective, this provision is really not essential in the way the legislature is drafted.
Okay. So basically, the review would address two things. One is ECR, the second is Section 45.
Yes.
Any takeaways from the judgment that you would like to share with the viewers who are interested in this? Maybe one or two interesting takeaways from this judgment of Justice Kanvilkar, parts of which are being challenged.
So in fact, there are which are under challenge. The third main issue, and I'll touch upon this because this is in fact the most important according to me in terms of the way a trial proceeds. Money laundering, if you see on a logical front, is what? Money laundering is the act of you derived, say, a proceed of crime. You derived money, you derived through a criminal activity, there is some proceeds which are generated. Converting that proceed from being untainted to untainted so that it skips the organization, it skips the first eye level is what the money laundering exercise is. So I'll just give an example. I'll give an example which is easier to understand in the transactional cases that we've seen operate, and this is very common. So most banks have, in cases, given a letter of credit facility to the company. The company avails the letter of credit facility. It gets the letter of credit and gives it to, say, its counterparty. Now, in connivance with that counterparty, the company which is accused in this offense tells the counterparty to discount the letter of credit out and give the money into my other sister company. That sister company will then transfer it to some other company and bring it back into this company as a share capital infusion. It's a classic case of money laundering. Now, in this case, the first criminal activity, the act of cheating, is to tell the bank that, look, I need this LC for I've done a shipping transaction with them. Whereas actually there is no shipping transaction. So that's a cheating. That's a classic case of cheating. But this by itself is not money laundering. The fact that keeps the money with it. Even till this point, there is no money laundering. When does the laundering start? The laundering starts when this money is routed by the main accused into his other companies and brought back. Because that is the untainted that he's given to this tainted money. And that was the classic definition of money laundering under our Section 3 of the PMLA. In fact, I'll just share 30 seconds here to tell you, in 2002, when the bill was being deliberated upon, this part was not there. In light of our UN conventions and other legislations in UK, US, this was actually added at that time to say that you cannot just have a standalone provision to say, aapne paisa rakh liya. You've taken the money with you and that amounts to money laundering. You have to do some activity over it. So that amounts to money laundering. That was very much there. Now, what happened in 2019 is that this definition is altered and elaborated of crime and the act of projecting tainted money as untainted. This and is now today converted into or. So the fact that I have the money, even if I'm in possession of that money, with an intent that I will do something, today the ED can come after me to say, oh, this is proceed of crime, you've committed laundering, which does not factually and logically make sense.
So are you saying that simply, for example, if you rob a jewelry showroom and you have cash with you, but then you don't convert that cash into, say, a house or something else, then it's no money laundering. It's only robbery and so much.
Correct.
What you are saying effectively is that money should be legitimate asset.
Yes.
Could be shares, could be
anything.
House, farmhouse, anything. Only then laundering takes place.
Yes.
But as of today, you are saying the act of robbery itself makes you liable to be charged with laundering. Is that what you say?
Yes. And that not only illogical, but also unconstitutional. That goes against the very principle of money laundering. And that's one of the fundamental challenges to the definition of Section 3 today in the review.
Basically, what you're saying is projecting tainted money as untainted is, as per the present situation we are in, without even projecting, you can be accused of money laundering.
In fact, I will take this. Yes, your example is spot on. In fact, the incongruity goes a step further. Let's say I rob a bank I'm running with the cash. I see the police running after me. My accomplice is on the way. I see his car. I throw the money into his car, and he is now caught with the money in his car. He has not robbed the bank. But since he's in possession of the proceed of crime, which till now has not been untainted, he also will be part of my ED investigation, and he'll be accused.
Anybody after this guy robs the jewelry showroom, any person that he's given this money to is also liable to be booked.
Yes. Yes.
So a lot of innocents can also be booked.
Correct, because in a chain of transactions where there is money laundering, there will be genuine counterparties. Now, in the example that I've given you, there will be counterparties who are actually doing this business.
All this will be taken up in the review petition. That even all these aspects are also being taken.
Absolutely, because mere possession cannot lead to money laundering, and that's the argument.
I want to ask you also one thing, that in this act of, say, robbing a jewelry showroom, if it is tomorrow proven that I had indeed not robbed that jewelry showroom, it was somebody else, then does my laundering case also automatically, in a sense, I'm acquitted of that charge also, which is a...
Yes. So in fact, this is one part which the Supreme Court has ruled in favor of the accused, to say that ED cannot be, if the predicate offense goes. Yes. If the predicate offense either gets closed, you are discharged or acquitted, then your ED investigation has to close against the person who stands acquitted.
Automatically.
Yes. In fact, very interestingly, 2 days back, there was a judgment by Justice Yashwant Verma of the Delhi High Court in a case of Prakash Industries, where he said what to attach, because they feel that's a money laundered exercise. If there is no allegation of a predicate offense for that property, you cannot attach that. Okay. And these are the problems. See, that's what I'm saying. These are the problems arising from this Supreme Court judgment, because today the ED's 3 and the attachment proceedings is so wide that no one really knows what exactly is the laundering exercise.
In fact, on the next show that we do, we will discuss attachment also, position also, the extent of attachment, the value of attachment. All these issues are of great concern to businessmen and promoters who are being prosecuted under these charges. Of course, very soon also this case will be heard by the Supreme Court. A bench would be constituted. We are all waiting for that. And then we'll also get the time to revisit these issues, because I think that's when there'll be keen interest. Courts will pass some comments. There'll also be observations, arguments. But I think this was a prelude to, in a sense, the case that's going to come up in the Supreme Court. I would, first of all, thank you for sparing your time. Judgment, also the review petition, and also the key points that are going to come up before the bench. It will be useful for the viewers, and I would also like to thank the viewers for joining in. Thank you so much, Malak Bhatt, for making time. Thank you so much.
Thanks.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.